Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Section 126, Professional Communications. Now, try to imagine that you are speaking to an advocate and you are his client. Now, if you are disclosing some communication or disclosing some information to your advocate, whether he can disclose that information to anybody else, the answer is no. He cannot disclose the said informations except without your express consent. Then the next aspect is whether he can disclose the contents or condition of any document which you gave to your advocate. He cannot do so. And the third thing is whether he can disclose any advice given by him to you. The answer is no. However, there are certain exceptions. There are provisos. The first one is when such communication is made in furtherance of any illegal purpose. Imagine you are speaking to your advocate with an intention or motive of an illegal purpose. Then in that case, the advocate can disclose the information. The second aspect is when you engage an advocate and that advocate comes to know that certain crime or fraud has been committed after his engagement as an advocate. In that case, he can disclose the information. However, the explanation says that an advocate who has been engaged is bound to disclose the information even after his employment or engagement has ceased. Now let us move to the examples that are provided in this section. Example A. A is a client. He says to B, who is an attorney, that I have committed forgery and I wish you to defend me. So the client is saying, yes, I have committed forgery, please defend me. Whether you can disclose this information, the answer is no. The advocate cannot disclose the information. This is a protected communication. Next illustration, B. The client goes and says to the attorney, I am planning to obtain the possession of a property by way of a forged document and I request you to sue using that. This communication being made in furtherance of a criminal purpose is not protected because it is obvious that the client is trying to do something wrong and it is a criminal act, illegal act, then that is not protected. Next is example C. Now, a person A is being charged of embezzlement. Then he retains an attorney B to defend him. Now the case is going on. B has been engaged. He is going through the accounts book of A. At that time, he is finding an entry where he finds a proof that his client, that is A, has embezzled the money. In that case, he can disclose this particular information it is not protected from disclosure since this fact proves a fraud which has been committed. Section 127. It says Section 126 applies to interpreters, etc. So there could be a basic question in the exam where they might ask you whether the provisions under Section 126 is applicable to the clerk of an advocate or the servant of an advocate or the interpreter. The answer is an yes. This protection under 126 is applicable to interpreters, clerks or servants of barristers as well. And whatever be the provision to disclose will also be equally applicable. That is Section 127. Section 128. Privilege not waived by volunteering evidence. So, if a party in a suit voluntarily comes and gives an evidence, it doesn't mean that he has consented to disclosure of the aspects or the communication what he had with his advocate as provided under Section 126. And if there is a party to a suit or proceeding and he calls the advocate as a witness, then he shall be deemed to have consented to such disclosure only if he raises the question pertaining to that aspect to the advocate. To make it much more simpler or to simplify the particular aspect of this act, if this question is not put to the advocate, he is at liberty to not disclose the communication. Section 129. No person can be compelled to disclose any confidential communication which he had with his legal professional advisor unless that person or the client offers himself as a witness. In that case, the witness can be compelled to disclose the communications in order to explain the evidence what he has given. Section 130. Production of title deeds of witness, not a party. So, imagine that you are holding title deed of a particular property. Then no one can compel you to produce that document. Or if you are holding a title deed by way of a mortgage and somebody has mortgaged that property to you and you are holding that deed, in that case also no one can compel you to produce that document unless you had agreed to that person that whenever there is a requirement I will produce the original deed. And if a document or production of a document would tend to criminate him, then in that case also a person need not be compelled to produce the said title deed. Section 131. Production of documents or electronic records which another person having possession could refuse to produce. Imagine, I am giving my own documents to my friend. In that case, whether my friend can directly produce it, the answer is no. Because I would obviously refuse to produce the document if that was in my control or possession. In that case, unless I give a consent, my friend cannot produce the document. Section 132. Witness will not be excused from answering a question on the ground that if he answers, it will criminate him. So to put it in a simple manner, if I am a witness, a question is being asked and I refuse to answer that question, saying that if I answer this question, I will be subjected to a penalty or a forfeiture of any kind. This will not be accepted. So there is no excuse on this ground. However, if a witness is compelled to give an answer in this particular question and he answers that, just for the reason of answering that question, he cannot be arrested or prosecuted, except if he gives a false evidence by such answer. Section 133. Accomplice. Whether a statement or whether a accomplice can be a competent witness. An accomplice shall always be a competent witness. However, a conviction based on the statement of the uncorroborated testimony of an accomplice cannot be challenged merely because it is uncorroborated. Section 134. There is no specific number mentioned with respect to witnesses. In a case, there can be any number of witnesses. There is no restriction. It can be 1, it can be 10, it can be 100, it can be any number of witnesses, since the law does not stipulate the number of witnesses to prove any fact. I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video, or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.